Well, hello and welcome to the Prince Live. Today we are going to discuss whether all the parties in the Ayodhya dispute got a fair hearing or not. So before we barge into the main question of the live, it's imperative for us to discuss why are we here today. So after 40 days of grueling and intense arguments by all the parties in the Ayodhya dispute case, the Supreme Court five-judge Constitution bench, headed by the Chief Justice of India, Ranjan Gogoi, has at last reserved its verdict. The Chief Justice is set to retire on November 17th, and the verdict is any time before that. In fact, CJI Gogoi once had also remarked that if they are able to deliver the verdict within 4 weeks, which also has Diwali holidays accounted for them in between, it would be a miracle for the court to deliver the verdict in such a contentious, controversial, and legally complicated case. So when we talk about whether all the parties got a fair hearing or not, we should also know who were the parties. So in the common parlance, we only know that this case is divided between the Hindus and the Muslims. However, the party structure looks a little bit more complicated than just being Hindus and Muslims. So firstly, Mr. Gopal Singh Visharad was the primary litigant in the case, who started this entire litigation in 1950. Thereafter, there were several other Hindu bodies which joined the case, including Ram Janmabhoomi Nyas, Ram Lalla Virajman. And in fact, Ram Lalla Virajman, Lord Ram, the deity who became a party to the case, it happened way back in 1980s when a former judge, Mr. Devakinandan Agarwal, approached the court as a guardian of Lord Ram to implicate him in the case as one of the petitioners. That was done because we see Lord Ram in the case as a perpetual minor here who is trying to stake claim to his own birthplace. Then we have Ram Janmabhoomi Nyas, we have Ram Janmabhoomi Purandhar Samiti. Then there are other Hindu bodies involved in the case. The next is Nirmohi Akhada. Nirmohi Akhada is a sect which believes that they have the Shibetship rights of Lord Ram in this case, and they believe that they have the worshipping rights of Lord Ram, and they have been the guardian and the owner of this entire piece of land since 200 to 300 years for us to say. After the Nirmohi Akhada comes the Muslim bodies. Muslim bodies, one of the most primary and important party is the Sunni Waqf Board. Thereafter we have the Shia Waqf Board. Then we have a few individual litigants, Muslim litigants, in this case, which counts to about 4 or 5. So all of these people had to get a primary opportunity to argue in the case. So when we talk about a right to fair trial, a right to fair hearing, it is in fact one of the fundamental rights enshrined in the Constitution. So after 40 days of hearing, we must realize that the crux of time that was given for arguments was like this. On the 6th of August, when the arguments began, Nirmohi Akhada began its submission. After Nirmohi Akhada wrapped up, it's that Ram Janmabhoomi started its submission. After Ram Janmabhoomi finished its submission, Ram Lalla Virajman began its submission. Thereafter, the Sunni Waqf Board took. And before Sunni Waqf Board could take up, even Senior Advocate P.N. Mishra, who was appearing for Ram Janmabhoomi Purandhar Samiti, took over. So it was a completely chronological order in which all the litigants, represented by their own lawyers, were given chance to represent themselves in the suit. So there was indeed a fair hearing that was granted. In fact, today was a day, and the last 3 days wrap-up proceedings were going on, in which rejoinders and rebuttals and replies were being filed. So what happens exactly in a case? How does the arguments usually happen? So there is always a petitioner, there is a respondent, and especially if it's a title dispute case, then there is the one who argues that they have a claim to the title of the suit, and there's another set of people who say they have the claim to the title of the suit. And this entire case in the Supreme Court was a result of a 2010 Allahabad High Court judgment, which ruled that the land would be divided equally between 3 parties, Sunni Waqf Board, Nirmohi Akhada and Ram Janmabhoomi, in 1/3 each. However, the parties said that this was not one of the grounds that they had prayed for, and in fact the Hindu parties had said that the right to access the temple was in the Waqf land according to the temple of division that was made by the High Court verdict. So that's the backdrop of why the case landed at the doors of the Supreme Court of India. Also, a very pertinent legal point to mention here is that even though we are saying that the judgment has been reserved today and the judgment would be delivered within a month, let's not forget sight of the fact that there also exists the possibility of this case being referred to a larger bench for further reconsideration. However, that is again a matter of law and discussion that might happen, and someone needs to approach the court for referring this case like what happened with the Ismail Faruqi case also, when last year when it was decided, when it was being seen whether we can decide whether mosque is essential to Islam or not, as was pondered upon in the case of Ismail Faruqi, and later it was the court declined that it must not be referred to a larger bench. Similarly, Ayodhya verdict could also land up in a similar legal tangle. However, as of now, the hearing is over after 40 days and a verdict is expected in the next 1 month or so. We are waiting for your questions. We have a question from Mr. Chandan Kumar. What is the role of Waqf board? See, Waqf board is basically what is Waqf? Waqf is the custodian of properties of Muslims which are used for the purposes of their own community. So when we're talking about Babri Masjid, when we're talking about the site where Babri Masjid was located, because the masjid is no more there and it has been demolished, Waqf comes into the picture, the locus standi comes into the picture from the fact that they were the custodians of the property, because the property becomes Waqf. If the property has not been willed to anyone, then the property becomes a property of the Waqf so that it can be utilized for the community. There's always a case of a private mosque or a private temple, but in this case, Babri Masjid was not a private mosque. It was not a mosque that was owned up by the state, and hence the Sunni Waqf board claims its right and draws its locus in the case from this particular fact. There's also one important fact that today, when the arguments were going on, when certain points of arguments were being made by Ram Lalla Virajman, where it was said that there is no evidence on the side of Muslims that they had possessed the land or they had the title of the land, the other party, so as to say, the Muslims were completely miffed with this argument, because they believed that the Babri Masjid was indeed there. It was built in 1528. It was indeed built by Babur, and there was no temple demolition that happened. However, the entire case of the Hindus is that there was a massive structural temple beneath from where Babri Masjid was built, and it was that temple that was raised down so that this entire mosque structure could be built on. They also tried to prove that there were Hindu images and figurines inside the mosque, which essentially proves that there was no prayer held in that site. And the Hindus have also argued that, leave alone the temple, the entire land for them, and it's a juristic entity for them. So when we talk about the entire land becoming a legal entity, that is a claim which the Hindu bodies are now making in the disputed site, whereas the Muslim bodies have completely refuted that. So when can the verdict be out without, when can the verdict be bold without any ifs and buts? So let's remember a particular thing, that this entire case might look as a case between the Hindus and the Muslims and a communal fight. However, the court in this case has to walk a very thin ice of faith, travelogues, memory and evidence. This is also important to know that in law we often say that it's only evidence which matters in the court of law. But throughout these 40 days of hearing, if you peruse over evidences apart from what has been submitted by the Archaeological Society of India, it was mostly travel tales, historians, authors who had written and who had imagined or who had actually stated that they had seen the Ram temple there, and there was no mosque there at that point of time. So those articles and those stories have become a part of the arguments over these 40 days. So the court has to really walk a very thin ice to decide whether all those travelogues and memoirs and memory statements that have been highlighted in the courtroom, whether they can be admissible as evidence or not, and whether at all it establishes the case of the Hindus or for the Muslims, so as to say. There is one point which the Muslims have tried to prove in the court, that there was indeed a mosque that existed in the place, and they indeed prayed in the particular area. In fact, they also showed records to show that the Imam was appointed in the place, and how shoes were stolen during Friday prayers, which essentially showed that there were a lot of people who were taking part in Friday prayers, essentially proving that the place was being used for Muslim prayers. So keeping all these in mind, the Supreme Court has to give a verdict. Obviously, all the parties expect that the Supreme Court would be giving the land to any one particular party. However, there are interconnections involved here. Like, if Nirmohi Akhada is given the land but not Ram Janmabhoomi, then what would Nirmohi Akhada worship there? A very important point. Nirmohi Akhada is not an independent party. Nirmohi Akhada worships Ram Janmabhoomi. it worships Lord Ram, the birthplace. However, if the court says that it's not the birthplace, then the entire, locus standi of Nirmohi Akhada becomes null and void. In fact, that is why once in the hearing, when Nirmohi Akhada went on to argue that we want our worshipping rights and we don't care whether the Hindu bodies get their Ram Janmabhoomi or not, at that point the CJI had interjected and said that you fall together and you stand together. So this kind of argument will not yield any result. So this important point is not to be forgotten, because the court has to look at all these complicated technical interconnections involved in the case. However, as far as the prayer is concerned, the prayer is very simple and clean to overturn the order that was passed by the Allahabad High Court, and also to determine whether Ram Janmasthan has the characteristics of a legal entity or a juristic entity. A legal entity is the one who can get into transactions, who can represent its own in law, and hence they have their own rights which a normal individual like you or me would have. So if the entire land becomes a legal entity or a juristic entity for us to say, then indeed Ram Janmabhoomi would be proven to have a sacred place, and there will be no place for a mosque in that area. And the entire area indeed means the entire area of Ayodhya where they claim Lord Ram to have taken birth. We have a couple of more questions. Sagar asked me, how can the court order on the basis of someone's faith? It is going to be a favor of Ram Mandir. So, this is a very important question, because if you remember, when we talked about triple talaq, when we talked about this temple entry case of Swami Ayappa, where women were not allowed, all of these cases, unfortunately, Sagar, rested on the fragile shoulders of faith. So when we say that a case rests on the shoulders of faith, it is always to be seen as to how the court interprets faith in this circumstance. So when you say that a particular land is where Lord Ram had taken birth, there is no birth certificate to prove that there is the birthplace of Lord Ram indeed existed there, but they have to go through whatever available evidence and material is there, and the available evidence and material are the travelogues, are the memoirs, etc. And also the belief, this is also one of the key arguments which Senior Advocate C.S. Vaidyanathan made in court, that the belief of the crores of Hindus is that the particular place is the birthplace of Lord Ram, similar to the fact how Muslims believe that Kaaba is the place where Islam originated from and where you should face and pray your namaz. So this kind of a comparison, when it was made, it is very important to see your question in this light and fact, that the court has indeed handled matters of faith earlier too and given verdicts which were acceptable by some and which were not acceptable by some, but this is nothing new in the Supreme Court of India. We have a question from Neeraj Chaudhary. Whom do you think to be leading in case based on facts? So we are in no position, Neeraj, to tell you who would be leading, because that will be complete, a travesty of justice for us to hear a rumor monger in front of you as to who would be leading the case. We are no cheerleaders of any of the parties in the case, but just so as to say, both the parties all the parties, 14 parties and all of them were solidly backed up in facts. They had their evidences, memoirs, travelogues, key documents, translated versions, etc., everything in place. It now only depends for the court to see which it would on which it would place more reliance on. It is completely a judge's call. It is completely a judge's conscience call. In fact, Justice Bobade had once in the hearing also said that evidences and books are all the same at all on all the sides. It only depends on how we see and whom do we believe to be a little more credible than the other. So I think that answers your question. There's a question from Mr. Dipendra Singh. Will this SC decision be the final decision? No, Mr. Singh, the SC decision will not be the final decision. Sorry to break the bubble, because there is a feeling that after SC rules, in fact the SC ruling might become a precedent, but in no way it will become a final decision, because obviously it can go through review, it can go through a corrective decision, it can you can file after the review petition lapses through, you can file for a corrective petition. If that lapses through, then you can make a plea for a larger bench to reconsider the issue. So there are a lot of things involved here. I'll give you a very, very simple example in this case. On a very hypothetical ground, if you see that the court orders Ram Mandir not to be built in the particular place, and the court orders that the land be given to Muslims. Then what happens in that case? Or the court believes the land be given to Nirmohi Akhada. Then what happens in that case? Then the government always has the route of opting to a legislation. We also, what happened in the Jallikattu episode, there was a legislation being there was a ruling by the court that it has to be prohibited. However, easing or owing to the public sentiments, the central government or the state government, in fact, got in a legislation in place to overrule the verdict. So, all those situations are possible in this case too. However, we have to look at this case as an academic exercise also, because after 40 days of arguments and after dilly-dallying for over 3 to 4 years, the Supreme Court actually sat down and heard the case at length and finished it off. Because if you remember, every other time the Supreme Court was only suggesting that have an out-of-court settlement, have a mediation, or try to sort it out or get the transcripts translated, etc., etc. But this is the only time when the hearing has been completed. So it's a little complicated for the case to be reheard again. Even if that happens, it's not going to happen very soon, and the judgment will be continued to be valid until and unless some other alternative measures are accepted or adopted, as discussed with you. Vishnu Bansal, I think your next question of is there any further appellate remedy is also answered. Vishnu Bansal, what possibility do you find of whose part winning the case? I think I had already answered that with Mr. Chaudhary. Each one of us are very interested to know, just like a cricket match, as to who is winning the match between the Hindu Muslims of the Nirmohi Akhada. But unfortunately, to break the bubble, we at the Print cannot speculate on who is winning the case. In fact, all of the parties were very well loaded with facts. And again, just to reiterate ourselves, it is completely a judge's call. If you ask me what were the arguments, of course I can elaborate on that. Just the key of arguments, the Hindu party said that the land is a juristic entity, it's a legal entity, and hence they have the complete right. Nirmohi Akhada said that they have the Shibaitship rights on the land. Shibaitship rights mean the right to worship, and the worshippers become the guardian of the place, and hence they have rights over the land. That is one of the key arguments of Nirmohi Akhada. And the Muslim parties say that the mosque was in existence in that place since 1528. It was built by Babur. There were no temples which had been raised down, and proper prayers were being conducted till the time the mosque was raised down in 1992, and hence the entire area is a matter of right to pray for the Muslims, and hence the land belongs to the Sunni Waqf board or to the other parties who are involved in the case, and the verdict must be in favor of the Muslims. So this is the crux of the arguments from all the parties. Whose argument you find more strength in? You were just trying to get the same answer from me through a different question, but if you ask me personally as to whose argument finds more strength, I would say all the parties, because let's not dismiss the fact that there has been immense amount of months and years of research that has gone onto this case. I was in court. I saw even after the case got over, Senior Advocate Rajiv Dhawan, Senior Advocate K. Parasaran, C.S. Vaidyanathan, all left the court together hand in hand, and it was the entire lawyer community which came together out of the court as one single entity and individual. It was not that they were bickering and fighting with each other after the courtroom drama was over. So let's just remember that this case is a very, very communally, emotionally sensitive case for most of the Indians, and because there are always cheerleaders from both the sides who some believe the mosque should be built and some believe the mandir should be built. But it is also a real test on how far the court can consider evidences based on memory, faith, travelogues. So that, I think, would be one crucial question for the court to ponder upon in this case, which should also act as a precedent for a matter of fact. Gauri Maz asks me, what's really happening in the court? Please elaborate. So what's really happening in the court, Gauri? For the 40 days, hearings went about, and today hearings were being wrapped up as each of the parties started filing the rejoinders, rejoinder arguments, rejoinder briefs, etc. All the parties were given a chance to close their arguments, each of the cases by issue basis. What also happened is that when Hindu Mahasabha today interrupted the courtroom proceeding and said that there needs to be a book, there is a book by a former IPS officer which could be taken as an evidence in this particular story or in this particular case, that this book also should be taken on record. But in that stance, Senior Advocate Rajiv Dhawan got extremely perturbed and started tearing those pages that were presented by the lawyer for Hindu Mahasabha, which kind of created a ruckus in the court. Later, the Chief Justice of India and the lawyers made it up in the courtroom itself and said that it was under the direction of the court that he was tearing the pages, and it was not a big hassle that took place. However, Chief Justice Ranjan Gogoi in the morning said that the hearings would be over by 5 p.m. but the hearings went on till 4 p.m. and the arguments were closed down. So that's what really happened in the court, and it was a very complicated hearing. You should read our pieces on ThePrint'In elaborating the arguments of each of the case. In fact, we have a piece 2 days before also elaborating what were the key arguments for each of the parties. So that piece will indeed give you some more details on how and what was argued from each of the case. I just a couple of minutes ago told you what were the key arguments on each of the parties, and the chronology was Nirmohi Akhada, Ram Lalla Virajman, Ram Janmabhoomi Nyas, and other the Hindu bodies, followed by Sunni Waqf Board and the other Muslim bodies. So that was the chronology of the case throughout these 40 days, and it has gone on to become the second longest hearing to have happened at the Indian Supreme Court, because or the Indian judiciary for us to say, because the first longest hearing was of Keshav Nanda Bharti case, Keshav Nanda Bharti versus the state of Kerala, which determined the basic structure of the constitution. Then till now it was the Aadhaar case, which went for about 38 days, but now with this case it becomes the second longest hearing because it went on till about 40 days. Aditya Padhaya asks, can SC give a verdict same as High Court? So I'll tell you something from my understanding. The SC cannot give a verdict on the lines of the High Court, because the High Court divided the land into 1/3 part each. When you divide a land into 1/3 part each, you're trying to reach a settlement between the parties, and that was not what was prayed by any of the parties in the suit. They only wanted to determine whether the land goes to the Hindus or the land goes to the Muslims, or the land goes to the Shibayat rights claiming Nirmohi Akhada. So in this particular scenario, they cannot give the High Court verdict, because first of all, it was not a relief that was asked for by the party. Secondly, if the 1/3 land division happens, and if you actually see the map of where the Ram Chabutra is, of where the Sita Ki Rasoi is, of where the Babri Masjid is, you will realize that the division left the access to the mosque as same as the Hindu land. The Hindus had to access the temple through the Muslim side, and it was going to be a very messy affair. So the court, in my humble submission and view, is that they cannot take the view of the High Court in this case. However, they can agree with the judges on some matters and points, but in no way can it give us extremely similar verdict or uphold the entire Allahabad High Court verdict. So I think this was one of the most controversial and important hearings in the Indian judiciary till now. Maybe in fact after Keshav Nanda Bharti also, because the Ayodhya dispute has been one thing which has kept the flames of politics burning, has kept the flames of academics burning, to understand how a case rests on faith, memory, evidence, and travelogues. So The Print is going to do more and more stories on this case. So keep checking ThePrint'In, and also subscribe to our YouTube channel, The Print, for more fantastic videos from our fantastic video team. This is Debayan Roy, principal correspondent for The Print, with more details coming up.